cut off the session so that people can have their lunch. So that's a huge responsibility. So I will start, obviously, by welcoming our panelists and thanking them very warmly for accepting the invitation. I think you hardly need any introduction. Angelique, you are today, I think for both of you there is the common point that you have a sort of double background, which I hope will give us an interesting perspective in the debate today. Angelique, you are heading Johnson & Johnson's Competition Law and Policy Group for the EMEA, and you're advising internally businesses and lawyers on pharmaceutical products, medical devices, consumer goods. But before that, you were in private practice, and you were working in Brussels and Paris at Freshfields. So you have this international perspective also from private practice perspective. And Paul, you are today a director at the European Commission's DG Competition. And you have in your portfolio, or should I say, the unit that is handling the cases in the life sciences sector. But before becoming a civil servant acting for the public interest, you have been, I learned, in private practice. You've exercised after you earned your degrees in Hungary and in the US. You've worked in an international law firm as a corporate lawyer. So that's, I think you know what it is to be on the other side of the barrier. So being in such good company, I will not introduce myself much other than to say that I'm a partner at a Paris-based law firm, Frèget Glasier Associès, and we are focusing on competition law, and we do work quite a lot in pharmaceutical cases, which brings me to making my first disclosure that our firm and I have worked on two of the cases that I hope we will be discussing today. Which has a drawback, obviously, because when you work on a case, you necessarily have a bias, and I will hope that I will stay as objective as possible, but you cannot avoid a certain level of bias, which I will try to channel into the questions I will be asking our panelists. The advantage is that I hope that I'll be able, or our two panelists who also know some of the cases very closely will be able to give us more insights and have really an honest and open discussion about them. So without further delay, let's go into the topic. I'll start by saying that a couple of weeks ago I heard one of your colleagues from DG Competition say that disparagement cases were in pharmaceuticals the new generation of cases at the Commission. And in France, as you know, we are kind of seasoned in this type of cases. So without obviously going into the confidential details of any pending cases, I think this is really an opportunity to reflect on some broader questions that these cases trigger, both in terms of public policy and enforcement, but also on the side of companies. What is the advice that today we should be giving companies in terms of communication that they are allowed or not allowed to develop with public regulators or with public authorities in general? So to start with an observation, clearly what we've seen is that the antitrust toolbox that was discussed in the previous panel has evolved over the years. So we are no longer in the parallel trade cases that were top of the hot cases in pharma some years ago. Even the pay-for-delay cases have sort of become mainstream now. We had more recently a surge in the excessive pricing cases, but today what's really sort of moving the national authorities, some of the national authorities, and now we see the European Commission is disparagement cases. So what is it, and how should we deal with this new animal? Before we try to get the reasons of this, I don't know if it is a policy shift or a normal trend, but we try to decipher what these cases mean, what signals they give to companies. I will turn to Angélique, who has known at least one of the cases, to make us a brief insider's look at the French fentanyl case, and maybe how it compares to a more recent ruling in France in the Novartis Roche Lucentis Avastin case. So in one instance, the competition authority reached the conclusion that there is disparagement and there is unfounded legal intervention, whereas in the other case, the Court of Appeal in Paris annulled in a very important decision, I would say, completely overturned a competition authority decision in this other case where it based its reasoning on freedom of speech and said, okay, there is no disparagement where the company has the freedom of speech and there is a debate of general. So what do you make of this, Angélique, and how do you see these two cases? Is there a contradiction, or is there anything else that we should be looking into?
Thank you very much, and it's a pleasure to be here. Maybe the classic disclaimer, I'm speaking here on my own personal capacity and not on behalf of my company, although, as Liliana was explaining, we've had this important case in France on disparagements, which gave me the opportunity to get up to speed on the topic, let's say. So I thought it would make sense, and when we discussed this panel, we thought maybe it would be interesting to go back to the recent cases, indeed, to set the stage and remind you a little bit what we are talking about in terms of disparagement. And maybe before reaching, the two most recent cases, which are indeed the Janssen Durogesic case, so that's our Johnson & Johnson case, and the Novartis case, I wanted to address a couple of older French cases as well, which probably, were set the ground, so to speak, for disparagement cases in the pharma space. And obviously, I'll let Paul maybe address the two most recent EU cases that are ongoing. They didn't lead to a decision yet, but it's interesting also to see that in this case, we started with national cases, and eventually the Commission also started cases. And I'm sure Paul will address this as well in terms of opportunities for the Commission to address those cases as well. So I think one of the first cases I wanted to discuss was the Sanofi case, a French decision from 2013 that went all the way to the Supreme Court. And there, Sanofi was found to have infringed competition rules because basically while the generic version of their medicine, Plavix, was just about to be launched, they started a campaign, let's say, or a strategy to try to limit the substitutability of their product with the generic version. So they basically had a number of ways to do that. One was to provide practitioners, so HCPs, healthcare practitioners, with some warning that the prescription drug, so the originator drug, was not substitutable. Although, if you are a generic, there is a presumption of substitution. So they used some arguments, including the fact that although they didn't have a patent anymore on Plavix, they still had a patent on one of the elements, which was some salt component. And they were considered to suggest to HCPs that, the fact that the generic version didn't have this component with this specific type of salt meant that there was a difference in the quality effectiveness of the product and that they were not substitutable. So they basically created some doubts in the HCPs as to whether they were substitutable. I think this decision is interesting, and I'll come back to this after, because to some extent, they didn't really, contrary to the classic AstraZeneca case in the past, it's not like they gave wrong information, because there was a difference. The salt was not the same, but it was still considered to be misleading. There was another case which I think I will skip. But maybe, yeah, moving to our two most recent cases. So in our case, we got a decision back in 2017 from the French Competition Authority, considering that we abused our dominance in relation to Durogesic, which is a fentanyl-based painkiller patch. You will have heard about fentanyl. It's an extremely strong drug. This is something which is only delivered on prescription in extreme patient cases of, very, very strong pain. And in that case, the French authority considered that there were unfounded and repeated interventions before the French Medicines Agency to put into question or to contest potentially the substitutability of our originator product and the generic version that was just about to be released. And then they also considered that we engaged in a campaign vis-à-vis HCPs to stress the difference between our patch and then the generic version. In that case, obviously, I am also biased, but there was genuinely a difference because the dosage of this fentanyl in the patches was different. And we actually, it was before my time, I must say, so I did not advise internally on this case, but our teams at the time thought that this difference should be raised to the attention of the Medicines Agency, because they considered that the substitutability shouldn't be automatic, especially with respect to certain categories of more fragile patients, so older patients and younger patients, and that it should be, the substitution should only happen with, the advice of your doctor, basically, in that case. So they raised the attention to the French Medicine Agency, and they also raised the attention of the healthcare professional. And that was considered anti-competitive. I must say, to be honest, and for the little story, that on the campaign vis-à-vis the HCPs, it was quite interesting to see that the teams were very creative, that they, among other things, they have also had created this pop-up system in pharmacists' systems that if a pharmacist was going to, give the generic version of the fentanyl, there would be a pop-up raising their attention to potential risks, let's say, which in itself was considered, as a problem, obviously. But to come back on the more, how would I say, controversial aspect, which is raising differences vis-à-vis the medicine agencies, there was clearly a really, really totally different position there with respect to our position and the competition authority's position, which considered that once the generic version had been approved, actually at EU level, not at French level, the substitutability should be automatic, and we had nothing to say in that process. Interestingly, in that case, that engagement and discussion with the Medicines Agency led to the issuance of a warning notice in the generic version of the fentanyl, saying that indeed, when it comes to this specific category of patients, the younger ones and the older ones, the more fragile ones, then the substitution should be supervised by a healthcare professional. So it's interesting in that case, I think, that you see that we had legitimate reasons to raise not suspicions about sustainability, but concerns, let's say. We did it, in an objective manner, engaging with the authorities. This led to a notice, and we were considered to have abused our position, dominant position, by somehow misleading the authorities and de facto delaying the authorization for the generic entry in France. So obviously you can understand that I am based. I'm still not convinced that this was the right decision. But that raises, most importantly, some practical questions for pharma companies as to what can you and can you do. And I think in that case in particular, there is an important element, which is that pharma companies are under a duty of pharmacovigilance. So if you know that there is a potential risk for the patient's population, you have a duty to raise it. And I think in that case, maybe that argument wasn't really, was dismissed quite easily by the French Competition Authority. So we went on appeal, lost. We went to the Supreme Court, lost as well. So we ended up in a situation where we thought, and I was advising internally, saying, any interactions with medicine agencies or public authorities, you need to be extremely careful, even if this is not misleading, even if this is based on scientific evidence. Then came Novartis. So Novartis is a famous saga, I would say, in relation to the Avastin-Lucentis case. The decision dates from 2006. So that's the appeal decision. No, the original decision is from It's from September 2020. Indeed, they were fined for collective dominance. Novartis, Roche, and Genentech, 444 million euros, which is at national level a very significant fine. And there, the allegations, or actually the charges, were that the parties used misleading and alarmist treatment concerning the off-label use of Avastin. So those two products, Avastin and Lucentis, and Liliana knows much better than me, but we're actually not treating the same disease. But over time, some doctors realized that actually Avastin, which was cheaper, could be used to treat now I can't remember the name of the disease, to AMD, which stands for
age-related macular degeneration. Basically,
yeah, it's the
retina gets dysfunctional, and basically you lose sight. It's an old age-related disease, and you could lose sight until this medication was found that stopped the progression of the disease.
So Avastin was much cheaper. It was initially not supposed to be treated this specific indication, but then when...
It was a cancer drug, actually, so nothing to do with an eye disease.
Yeah, and on one patient in particular, I think they realized that this was also treating not only his cancer, but had also positive effects on his AMD. And that drug was literally three times cheaper than the Lucentis. And so there started to be off-label use of that drug for the treatment of AMD. And Novartis tried to limit that by stressing the risk of the use of an off-label treatment, basically. So I won't go too much into the details. I think this case raises lots of very interesting stuff, including, the collective dominance. I think another aspect as well is that this is a mirror case to an Italian case. So those in the room maybe have heard about the Italian case, which was under 101 basis. But just to finish very quickly on this case, went to appeal. In appeal, the Court of Appeal in France decided that actually it wasn't an abuse, that the parties raised. So they also engaged with public authorities, like in our case, and they raised concerns that were valid and were proportionate, basically. So eventually quashed the decision. So we are now, the case, I think, is going to the Supreme Court.
Yes,
so we are now in this situation where, it's not really clear, I think, for pharma companies how much engagement they can have with public authorities when it comes to factually based elements and arguments. And, I'm happy to come back on more practical aspects, what it means for companies advising internally, or what it means for lawyers advising pharma companies. But I will, pass the floor to Paul.
Thank you very much, Angélique. So, Paul, I guess the Commission, you're monitoring what's happening at national level, and how does the decision come to do what seems to me like a policy shift? I mean, I understand that the Commission goes after objectives like market integration, making sure that prices are not excessive, but looking into what has generally been dealt with by commercial courts, disparagement cases, it's a very commercial practice. It's behavior that goes before the judge. How does the Commission one day decide, okay, this seems to work very well at national level, let's do it ourselves as well? Or what are the priorities? How do you set your priorities in this matter?
Yeah, thank you, Lily. Good morning, everyone. I'm going to have a different style. I have to do a quick survey. Is anybody come from a Nordic country, Austria, Germany, Scandinavia? Raise hands. Because they eat lunch. Oh, there are two of them. They eat lunch early, so okay, I have to be strict on time. Number one. Anybody who's not a lawyer here? Raise hands. Oh, quite a few non-lawyers. So we have to have a rush course. I mean, a lot of young people here, also lawyers. I mean, the first thing in competition, I have to start in the sky, and then we're going to end up with disparagement in all of these cases. So even if you are non-lawyers, you know that law is about rules, right? So people spend 5 years or more in law school learning rules, and then they say, well, is this thing matches with these rules? Match, doesn't match. It's like speeding or driving rules, you know. Am I in compliance or not? Black and white. You know. You go to competition law, the first thing you hear from Nobel Prize winning economy is that, oh, effects matters. It's not exactly the conduct. It could be the exact same conduct, and in one case it's anti-competitive, in another situation the same conduct will be pro-competitive. So relax. And then lawyers get like, it cannot be. I was just taught either rules are this way or that. Either I fit in that rules. All of my professors ask me, do I have all the elements? If I have the elements, bingo, it goes this way. Okay. So that's just an introduction that you already have to loosen up thinking like a lawyer. Non-lawyers have that. Now, the second question, by the way, I have to do a disclaimer. I speak in my personal capacity. It's not what the Commission would say, blah, 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 number one. Number two, a little correction on competition law, because it came in that this is a new thing, disparaging cases. No, we have a whole set of unilateral, so-called unilateral cases which we look at, for example, divisional game, abusing the patent system, other exclusionary conduct, loss leading, predation, withdrawal, delisting, product hopping, all kinds of things which companies tend to do. So it's which case will be a priority? It depends on the facts, depends on who's complaining, and so forth, and limited resources. So I would like to diffuse this point that the main thing now the European Commission is disparaging cases, disparagement. No, not really. Again, what looks interesting. Now, what should be the general approach to these cases as well as generally? And here is the benefit. Hopefully nobody's going to go on the recording later, so you're going to benefit from this one big time, because the Commission is, at least when it does the right thing, thinks exactly like the defense lawyers. At just the end, they draw different conclusions based on the facts. And what is it? It is you want to understand why the company is doing what it's doing. You cannot approach it from, oh, does it fit in this? What are the check boxes? I have these slides. I can go through the elements, the indicia of disparagement, blah, blah, blah. But you really, especially if you're a younger lawyer, you want to understand, why your senior partner and the firm does this. Because it leads directly to the litmus test, what the Commission, or at least I'm preaching my colleagues in the last 15 years, should do, which goes back to the AstraZeneca litmus test, where the courts ask, is this competition on the merits or not? Now, lawyers would say, what a woolly test. What is competition on the merits? It can mean anything. So there's a shorthand test for that. When the company engages in a conduct, it costs time and money, right? Because the people are tasked, they do things, they go out, they have leaflets, they talk to everybody else. So why are they doing it? Is it the product's going to get better, more innovative? Is it the distribution's going to be more efficient? Are they lowering the cost? Or simply they want to make more money and they don't care that it's the same product or what is the cost. They simply want to make more money. So if you approach the activity, you pretty much see that what we call the economist efficiencies are there, the real efficiencies. Yes, if you want to innovate, if you want to cut cost, you've got to be faster, better services, better aftermarket services. All these things are pro-competitive because it will put pressure on everybody to do it better. If, on the other hand, you have a deliberate scheme somehow where you just say, why do they spend the time and the money on this thing? It ends up hurting a competitor one way or the other. Now, I'm not supposed to say that we protect competitors, and we don't. I don't care about competitors. But if a company which has a significant market power, which is for unilateral conduct, it's going to be dominant, large market shares, whatever, can act a little bit independently. If they do something where it looks like it's not leading cheaper, better, cost savings, more innovation, but simply making the competitor's life much more difficult, we call it foreclosure effect, right? It's in the parlance. Then you may have a problem. So as a young lawyer, because I see a lot of young faces here, you want to get a feel for that, and nobody's going to tell you. Of course, the client representative is not going to tell you, the senior lawyer is not going to tell you, but what is really having this theme designed by the company? That's already going to give you the smell test, so to speak, and ask questions.
Sorry,
yep, go ahead.
May I just interrupt? you?
Absolutely. Anybody, by the way, all of you, please interrupt me, and I love if you disagree, because
it just burns my...
absolutely.
We are here in a field where the outcome of an investigation is a penalty, which is a quasi-criminal, it's a criminal penalty. So in these matters, as a lawyer, and sorry, I'm reasoning like a lawyer as I was formed, you need to have some certain level of foreseeability. So when you say, okay, you're doing something, but actually we'll see what was the reason behind, and we'll see at the end whether it was competition by the merits. How can companies decide on their conduct if they don't have in advance the framework which sets the rule? We do need to function by a rule, and they only know in the end if it is anti-competitive, if it's competition on the merits or not. It's a criminal penalty.
I understand it's not an easy one, but first of all, as a lawyer practitioner, you should welcome it, because this is a field to make a lot of money. But you will not know it only at the end. You can get a good feel in advance, because again, if there is an elaborate scheme, a relatively elaborate scheme, or a set of conducts within a company, you simply want to ask the business people who proposed it where, which slides. These are all historical pieces of data or documents. Why it was in advance. If somebody says, guys, we should do something, we're losing sales in Italy. And then guess what? All the salespeople kind of go out and say, I'm wondering the efficacy of that thing. Well, maybe a little flag. I'm not saying it's a problem. So, you go into the historical set of documents within the company or interviews. I mean, I'm just guessing. That's what good lawyering would do. And you get a feel for it, why that conduct developed in the company. And again, if it leads to efficiency elements, then it's very good. I mean, in other fields, for example, companies change the label, change the size of it. You can trace it that there was a lot of parallel trade going from one country to another, non-existing borders. So the company made it a little bit bigger. It doesn't fit for recycling in the other country. Oops, the flow didn't happen. I mean, these are not speculative things at the end, and the commission is going to say, I decide this way or that way. No, the facts are there, pretty good indicia that changing the can wasn't based on that the youngsters, we all want bigger cans, please, in our country, we want bigger cans. Okay, that would be a very good defense. You don't find that document. You find, we have problems. A lot of things flow from the cheaper jurisdiction to, we have to protect our sales, the higher margin. What do we do? And then somebody says, let's have a bigger cap. You know, so it's the same with disparagement. I mean, I'm just jumping to the elements a little bit, and now this is like a deep dive here. So the promotion materials is not limited to advance the merits of the pharmaceutical product, but it's discussing the competing products' merits and the quality, right? So do we have to do that, really? And then we can talk about it, what's misleading. Because in other areas of law, like securities laws or whatever, simply stating pieces of facts, which is true, doesn't take you off the hook of not being misleading, right? Because there is such a phrase, omission of material facts, right? So if there is a product of your competitor and there are 5 articles which said about that product, I'm not so sure, we tried to test this way, monkeys, whatever. But there are 5 other articles which said, yeah, we also tested, but we find something else. And the salesperson mentions to the family doctor, my family doctor, whom I expect to be the most conservative guy when it comes to my health, I said, did you know there are 5, not 3, 5 articles questioning that thing? But forgets to mention that there are 5 other articles from equally reputable sources which said we didn't find anything there. Is this misleading? Is it a material omission of a balanced presentation? Is this the job of a salesperson to make this hypothetical claim? 5 articles about that of a drug which has been approved by the proper authorities. And this has to be decoupled with pharmacovigilance or some scientific debate if somebody, be it a competitor, have a genuine concern about certain aspects of another drug. But where do you go with that information? Where do you debate it? Which is the right forum to debate that? Is it the family doctor who actually does the subscriptions, who increases the volume or decreases the volume of the daily subscriptions for that? Or is it another scientific forum, maybe the health agency or the doctor's bar, where they come up with general recommendations and best practices, first line, second line, substitution issues? I mean, you know, different member states have different views, and their doctors, for example, on biosimilars substitution. In some member states, they say don't shift patients from one biologics to another one, to a biosimilar. Some say it's close enough, you can even shift it. I mean, this is a genuine preference. Okay, it's done by the health authorities, the guidelines. One can dispute this is better, this or the other is better. It's a different thing. But it's not for the salespeople, for the family doctor, because I expect, and I think all of you would expect, that your family doctor or first-line physician is the most conservative. He wouldn't take any risk. It's not out of his pocket, not out of your pocket. It's all reimbursed. So if there is a little omission of some material facts there, if I were an in-house lawyer, or if I were there, I would definitely ask why in the brochure this thing for the salespeople who are visiting the doctors ended up there. The 5 articles, I forgot to mention the other 5, right? Because you don't expect reasonably the family doctor to say, oh, there are 5 articles. You know what? I'm going to go to the library, read them, and we'll see the citations. Maybe there are other articles out there which kind of cited or disputed it. Everybody knows. The family doctor wouldn't do that. They would say, oh, yeah, 5 articles, okay. Well, we forget that drug. So it's relatively simple. So I just go through the list, and then I open the floor, because some of you, I'm sure, have some questions. So the first element was, it's not limited to boost your own super drug, but you know, you comment on the competitors, and then you get into this, is it misleading or not? We touched upon it. Then, often in these cases, both at member states level and our level, that this comes up in the context that you have a large incumbent, maybe the originator with a substantial market share, and the generic or a biosimilar appeal. The barbarians at the gate, banging, hey, I'm the same, but I'm cheaper. Come. So that's, again, for you practitioners, you want to wonder why suddenly the brochure changed, right? Because previous brochures were not mentioning that. Then it concerns material aspects of the product, safety, efficacy, equivalence with the reference product, and so forth, which, again, as I mentioned, it could be viewed misleading in the context. Who is the audience? The family doctor, the first-line physician? And is there an omission? I mean, I just always think the 5 other articles, right? So and we can argue that even if you tell the family doctor 5 articles this way, 5 articles this way, even that, is this really to influence the family doctor? But I say that's the weakest point from the prosecution side. Again, another thing, it's not pursuing public health goals. So you are, the similar claims expressly or implicitly are not made at other forums, which we mentioned, the regulatory forum. It just happens mainly in the sales channels. Again, that's something which would raise the fact. So all these things, all these elements, one would ask, can you characterize this conduct as not competition on the merits, which is the litmus test of our court? And then, of course, you also want to see some effects. You want to see that indeed that the sales of that other competing product suffered, right? Otherwise, you don't particularly care. You rely on agencies who regulate pharmaceutical advertisement and other things, and just some regulatory level. Again, I'm just repeating myself. I have some quotes here from the Advocate General's, quote, adversely affecting the decision-making process of those who create the demand for the 2 products concerned. Exactly. Like, whom are we targeting? The salespeople are not targeting the scientific board, right? They don't have the qualification. They don't have the background. They directly to go those who prescribe that medicine. Then, Advocate General. Communication of misleading allegations includes the dissemination of information which is in itself correct, but is presented selectively or incompletely, where, because of that manner of presentation, the information disseminated is likely to mislead those who receive it. These are an Advocate General statement. I don't have any issue with that. I mean, this is a pretty good statement to ask. It's not a totally loose, woolly test that some crazy official or some crazy judge will decide at the end, shall we punish this big pharma company or not?
I would have just maybe 2 objections on that.
Of course.
The Advocate General,
expected.
I think you're quoting from the...
And if I can react as well, if I can have 2 minutes
sure.
to react as well.
So the Advocate General also said that when the information is true, they shouldn't be, because the Advocate General was reasoning on, okay, is it a restriction by object, etc. And he said, well, if the information is true, you cannot even have an anti-competitive agreement because what is presented is being true. And it comes to your point, okay, it's exhaustive as information. But when you go to the regulator, the health regulator, which is mainly composed of scientists and pharmacists and doctors who are experts who are qualified to analyze this information, should there be a limit to presenting evidence, even if it's not entirely complete, because their job is to analyze this evidence and to have this scientific debate. So this aspect, which is very specific, and I totally agree with your arguments about disparagement and talking to healthcare professionals and the family doctor, but here in the two cases that we have in France, the Janssen and the Novartis, we had a case where the companies went to the health agency and discussed with these specialists and presented scientific evidence in one case, and presented even legal interpretation of something that's over there and can be subject of a debate. Where do you put the line on this? And I don't know if Angelique, you wanted to add.
No, exactly. That's one of the points as well. I think it's also, there are two additional points. The first one is that, competition on the merit doesn't necessarily mean that the practice that you do cannot have any commercial impact. You can do something in a totally legitimate manner, which also happens to be in your commercial interest without necessarily. So what I'm saying is that
it can also limit the sales of the competitor, which is the purpose of competition, basically.
Which means that, it's not because automatically when you decide something, it may actually positively impact your own sales, that this is by definition supposed to be anti-competitive.
I would like to 100% agree with that exactly, because those of you who ever will have the pain and suffering reading the 800-page decision of AstraZeneca translated from French to English, whatever, the court clearly says, and the general court clearly said that even dominant companies have the right to fight. So, and I would like to call myself, I never spoke with conclusionary statements. I said, what are the flags, what are the red flags, which lawyers, both in-house as well as you guys, as well as us, we should examine a case. So it's not easy at the end to see where the coin falls, and in some case was an off-label or off-authorized case. The second French case, which lost an appeal, it wasn't an officially authorized use of that medicine. So obviously there, ab initio, the leeway to say this hasn't even been authorized for that indication to use is broader for a dominant company than when something has been authorized and so forth. So these are all elements building blocks with which you can build two different stories. At the end, in the close calls, a company should ask itself, in my view, do I want to really go to push the limits? Knowing that maybe a regulator, be it as a national competition authority or the commission, at the end disagrees on whether it was at the end on the merits.
Yeah. Maybe, yeah. And that's just repeating what you said, Liliana. I think that at the moment, at least, there is clearly a perception of risk in engaging with medical agencies that are experts in their fields, that are able to assess, exactly to Liliana's point, whether the scientific evidence, which are not misleading in these cases, is well-funded to lead to certain conclusions, generic substitutions, off-label substitutions. And I agree truly that, especially in our case, I want to say, where that engagement, that discussion, and actually it wasn't a question of years, we're talking a couple of months actually of delay by disengagement with the authority, that led to a warning notice in relation to the substitutability. So it is, de facto acknowledging that there is a concern. But just to come back on another point that you were making, that what we see, you need to look at the strategy, and very often you see a large incumbent against a smaller player or new entrant. Yeah, obviously, these are the cases that you see, because these are the cases that are being brought to competition authorities because you're talking a dominant company. But, there is a broader question as well, which is, even if you're not dominant, can you engage with these authorities, these medicine agencies? Can you raise concern without risking, because it's 1 or 2 most of the cases, but in Italy it was a 101 case actually. So even if you're not dominant, you may still be held liable. Should companies now be concerned, or that any engagement with an authority may raise concerns? And I think that's where maybe we lack a little bit, and I'm looking forward, to the Commission's decisions for some further clarity on even the courts.
Clearly, I think I would not like to talk about Copaxone and V4 because those are pending cases. There are publicly made statements by the Commission in our press releases, so you can read what we are saying. We always say that just because we investigate something very seriously, it doesn't mean that the conclusion is foregone, right? So it may well be that we're going to stop the cases at some point, may well be, or we pursue for a statement of objections, which is a formal thing, and then even after a statement, you know the story. So I would leave those cases aside. I would just comment on saying that if a competitor, let's say a dominant company, engages only with the proper scientific community level, obviously it has, and it's done in a confidential manner, not that the newspapers leak immediately that the company went and had serious problems, so my family doctor reads it. Oh my God, we better put it on hold until then, right? Of course, that there, I would say, and my personal view, that's probably not the proper case to prosecute a case like that. Now, it may well be that you have an argument in favor of prosecution in a hypothetical case, if again, to that scientific body, very selective, biased information was given with serious omission of material facts. Because that's, again, if the same way as we have a merger review, and the law firm and the company would really omit very serious facts from the filing, we immediately say, hold on, you cannot make that omission. So even when you limit this to a scientific body, these are public officials, there's regulatory capture, they have less resources, the big sales volumes generate enough money to make the best scientific argument in favor of that company or making the distinction. So that's the starting point. So there is also a risk there, which is probably not a competition issue in a sense that the effects are not out there because the other product hasn't suffered yet. Maybe it's a scheme to make that product suffer. Oh, is it lunchtime or? But again, and perhaps I open the floor, or let's open the floor for comments, pros and cons, because this is a very complex area. Just last thing, free speech, that I say whatever I want to say, is obviously it's like property rights. We all learned it's not unlimited and not absolute. There are public interest considerations, and I would squarely put exercising free speech to my family doctor, which influences that doctor decision and persuades that doctor to decide differently than the official channels or marketing authorizations shaped it, because that would be a free-for-all, probably,
again, I
which
think
we as citizens don't
I think
want.
there is a clear distinction between addressing to the HCP population and pharmacists and addressing to, a very sophisticated team of experts as part of the authorities. But happy to.
Are there any burning questions or reactions?
Mario.
Very briefly, a comment regarding your point, regarding the indicators of a potential anti-competitive conduct. If I understand you correctly, at the end of the day, you're saying we need a good story, right? We need a story, and this means, after all, that you would need to identify a structured plan, I would say, with significant and cogent evidence. Otherwise, you wouldn't reach a threshold of materiality to go after a certain conduct. So
Exactly. And whether it's you're on the complainant side or whether you are on the defense side, good lawyering involves a good story supported by verifiable facts, right? That's all good lawyering. So if somebody takes it with a dose of skepticism, either as a judge or whatever, and starts to dig, your story holds up because the documents will be there. You remember the can or whatever, our sales are suffering. When you dig into three-year-old correspondence on that matter, salespeople and CEOs are paid when the bottom line is bigger and their margins are higher, right? So they often speak plainly. They don't come with constitutional arguments of free speech or whatever. They gotta say, our sales are suffering. They're suffering in Italy. What are we going to do about it? And then somebody says, we do new leaflets. We do, right. So these are all indicia. I'm not saying guilty, execute, cut the head, not at all. But everybody has to think, why? Is this going to be competition on the merits? Well, why the sales are suffering? Is it too much high price or the other is time, whatever. So you have to dig. And whatever the story is on either side, it has to be supported by facts. Yeah.
Any other reaction or question? If not, I think that we are...
Yeah, give it a little time. There are some, what about the students?
You mentioned limited resources in terms of when the Commission prioritizes what cases it looks at. I was wondering, are there budget constraints, or is this maybe not an area that is a priority? Is that why there are limited resources?
Yeah, we have a priority setting mechanism internally, discussing it at all levels, first at case team level, then unit level, then directorate level, and so forth, DDG level, whatever in the structure. Public resources are also always finite, so there's always a triage going on, and sometimes it's very difficult to change the relative order of the cases because there's always more potential in the pipeline, and obviously the merits, what evidence the complainant, informal complainant brought or came from other sources. There are many elements which feels into it. You knew, for example, for the pay for delay cases, probably we wanted to even finish this old one. Finally, that we have 3-4 on the map, so pretty much the area, the different types of conducts, we have precedents there. So there are kind of long-term precedent considerations as well to pick a case, and of course the relative strength of the case. And then unfortunately for some other good cases or potentially good cases, we don't have the resources. It's just like that.
So I think it will be even more interesting now to see the outcome of these pending cases that you're looking into, because whether there is a decision or whether there is no decision, it will be
one of them is a combination of two different lines, yeah. Right? The patent system and the divisional game issue. So that's like one of those hunting guns with two barrels. It's an interesting one.
Also, I think what's interesting is that so far we've seen cases between, disparagement between an originator and generic, between an originator and an off-label drug, and now I believe one of the cases concerns two originators. So it's also interesting to see how that is approached in terms of honesty of the debate.
What we have to keep in mind, and I'm sorry, one of those of you who needs to or wants to leave, I think it's very important to keep in mind how pharma companies compete also. That at different stages of their life cycle, the dynamics of their competition, hopefully if there is any, is very different. In the R&D stage, they watch everybody who puts in what in the pipelines. That's like 7, 12 years you can see ahead in pharma. I call it when the little turtles are hatching, you know, and they start to go to the beach. You know, they all go, there's no leapfrogging. Neither the only thing can happen that one turtle is picked up by a bird, the other is lucky, manages. So that's what industry does big time. The little turtle is going for 5, 7 years until marketing authorization, 10 years. That's a different, and they get money and they sell these pipelines, sometimes anti-competitively, as we all know, that's one. Then once you have marketing authorization, price doesn't really matter. Doesn't matter in the US, doesn't matter in Europe, because the decision makers, the citizens and the doctors are not really counting the pennies, so to speak. So then it's the competitions and on beauty contest, on detailing. I'm the best, I'm this and that. And that's where disparaging comes in. And then the big event comes, which I'm never invited to these life cycle management seminars, right? For big pharma, I'm excluded, I'm banned from them. The biggest threat, what comes at the patent cliff? Oh my God, the barbarians, the generics, the biosimilars, what are we gonna do? What are we gonna do? And there is many ways to skin a cat, as they say. One of them is disparaging, the other them is the divisional game, the third one is buying outright or whatever, or the IP source. It's a big palette, but you find the internal documents. Why? Because the CEO is making a bonus of 30 million if the bottom line is good. Of course he's going to ask his people, how can we avoid the patent cliff? You know, in the old case, one of the old pay-for-delay cases, you see internal documents where they're going to say, yes, at the end we're going to lose this and then we're going to lose the patent, but it's going to give us 6 months. That's $500 million pure net profit. Next one.
But that's the life of commercial companies.
Of course. No, I have nothing.
Especially in the pharma, where the investments are huge, and it's all the more important to have a level playing field.
But this is very important for this audience, especially because we have young people here. I have no problem with capitalism, and this is how it works. And the CEO has to make that money. And you have to have venture capital, so you have to have the biotech and innovation drugs. There's nothing wrong with that. There's one problem. The problem is that, which is different than an iPhone or different than a soda or whatever, that medicines are based on finite resources of every country, even the richest country, right? And if you have a generic out there, which was the grand bargain, you invent a great drug, you get exclusivity for 15 years or whatever. Jackpot. Keep collect the money. God bless you. Put it back to R&D or whatever. That's right. But after that, sorry, the bargain is over. No more extra 6 months, or no more this, or no more that. Because when there is overpayment for that particular drug, always think there's a hospital bed which your neighbor or your grandmother didn't get it on time or something, because there were finite resources of the medicine everywhere in Europe. So it's not like the iPhone. I mean, if families want to buy the next iPhone, they overpay for that, and they don't buy green food for their children, it's another issue. But for medicine, I think there's a heightened obligation of public service to make sure that we keep the system as efficient as possible. And part of them is that if there is a conduct which is not competition on the merits, as the chief judge is declared, we should try to do something about it for our common interest. And with that note, we can go to lunch. No?
Thank you for giving us that really public service-oriented view of the competition game. So thank you both of you for having this interesting and passionate debate, and I hope to bring it over to lunch as well. So see you later.